hear the next Fireside chat on India's innovation playbook, AI, IP, and the next techniques of revolution by Mr. Shashank Upadhye and Mr. Abhay Goel. So anybody who is interested in IPs and AI, the next tech revolution. Associates, today's technology and yourself with artificial intelligence, I would request you to come back and take your seats. Chinab 1 has been all about AI, branding and technology since morning. So I'm sure they need to take a coffee. Although the discussions had been very, very amazing and cutting edge. So I think they are awake and they'll just grab a glass of water and be back. That is interesting. Technology kept this room buzzing since morning. So we had audiences, standing industries, and India rises as a global innovation hub. The intellectual property protection is more critical than ever. This fireside chat explores how AI-driven advancements, strategic IP framework, and policy shifts are shaping India's tech future. Join us. Join us for insights on building, protecting, and scaling innovations in the age of AI. We have our speakers, Mr. Shashank Upadhye, partner Upadhye Tang LLP. He uses his inside and outside counsel experiences in pharma, devices, IP and FDA law to help brands and generic drug companies to launch and protect marketed products. He spent many years as Chief Legal Officer, Global Head of IP, FDA law at several pharma and device companies in the US and abroad. He helps clients with corporate compliance and board governance. He is the author of the 1400 plus pages book, a treatise on pharmaceutical patent and FDA law. Ladies and gentlemen, join your hands to welcome Mr. Shashank Upadhye. Our second speaker of the evening is Mr. Abhay Goel, co-founder and CEO at LogicApt Informatics Private Limited. Mr. Abhay is responsible for overseeing company's day-to-day activities. LogicApt provides with high-quality patent research and analytics. The team of experienced professionals is working round the clock to make sure that you are not left in doubt with the assurance and quality of work. Abhay has been leading some of the biggest and most challenging client relationships with patent attorneys, research and development teams of technology companies, IP managers, chief level executives, general counsels, corporate strategy, staff and law firms for providing technology scouting, patent prosecution and litigation support. Please welcome Mr. Abhay Goel. Let's discuss about India's innovation playbook, AI, IP and the next tech revolution.
Hi, good evening everybody. Thank you Shashank for joining me.
Thank you, Abhay, for having me.
Right. So how we're going to structure this conversation is, we're going to talk something about the past first, then present, and then future. So talking about the past, Shashank, I know internet was a major thing in terms of IP world. So what were the emotions when the internet came in? Were it similar to now what AI is doing to IP world? Because over 27 years you have seen all of that.
Right, and so thanks Abhay, and I want to thank also TiECON for inviting me here to talk. I've been around the block, and you can see, because in this picture I have much more hair than I do right now. So I've been part of a couple of different revolutions. Obviously the first thing was the internet, and the internet raised a tremendous number of intellectual property problems. We have to kind of go backwards in time and think the first thing that happened was copyright issues, right? People were copying websites, they were copying the content of the websites. The internet allowed you to share music, right? Remember Napster, Grokster? They allowed you to download movies, which you're still doing today, right? And you could do that into the torrents. It was a tremendous revolution. Trademarks was another one, right? So again, registering domain names. The internet was huge, and it caused a lot of issues because we didn't understand the full nature of the intellectual property. It took a number of years for copyright to mature, for trademarks to mature. But then the internet started one thing that no one ever really thought of, maybe something relevant to you, and that was the patenting of software. How did you patent software? I was part of that revolution 15, 20 years ago when the US patent offices and the European patent offices didn't know how to allow software patents to be patented. Could they even be patented? And then we saw legislative reforms. So in the past, it was a Wild West, and AI is going to be another Wild West, although the issues are going to be roughly the same.
That's insightful. So, do you think in today's world, AI is just artificial, right? So can it really invent something on its own? Because from what I know, it runs on some LLM models which are eventually trained by human beings. So do you think AI, because we hear this all the time, oh, how can AI be an inventor on something, but can it really invent something?
Right, so again, and Abhi is, brought up an important point, because the question first and foremost is, when we use the word, oh, I invented something, am I using that in the plain English sense, that everyday sense, like I'm talking to my wife or my kids? Now, I'm a patent attorney by training. If you talk to me about invention, the first thing I think about is the legal requirements of invention. So people will say, oh, I developed this, I discovered this, I invented this. But as a patent attorney, I say you've done nothing in terms of invention. You've done a lot of work, but you haven't invented something. So for AI, the questions of invention become, number one, can AI actually invent something? And then the question is what the result invention under the law? And the law is pretty much the same all over the world, right? Is it an invention law? And then the question is, who is the inventor? So what we have now, at least in this first generation of AI when it comes to patenting and invention, is that many countries around the world, the United States Patent Office and the European Patent Office included, have said that pure AI cannot be an inventor on patents because it doesn't have any human or humanity behind it. And the reason why that is that because the legislation or the underlying statutes and codes say that all patents must be filed by a patent applicant, and patent applicant has to name inventors, and the inventors must be human. So when we think about can AI be an inventor today? No. But what's the difference? Maybe the law has to change. If the law has to change, how does it change? Through case law or through the legislative process?
Okay. So this is more related to patents, but if I talk about copyright, say I generate an image on AI which is through some prompts, and that image is generated. I mean, I assume there will be all type of copyright problems in the future because who knows who owns copyrights on them, and then this was just generated by AI. So how do you think courts will look at this, and what is going to be around it?
Right,
Images.
so with AI, and especially when it comes to images, so let's just do a hypothetical. Supposing I go into ChatGPT and I take my today's picture, the picture that this gentleman or this gentleman is going to take, and they send it to me. And I say to myself, oh my God, the light is shining on my bald head and it's creating a flash over here. So I go into ChatGPT and say, ChatGPT, create an image of Shashank standing on the chair at TiECON with a full head of hair, right? And take out all of the shininess from the bald spot. And then, oh, by the way, I'm gray over here, so can you just make me look younger and make it look black? Now, typically, a photographer could do that in Adobe Acrobat or Adobe Photoshop before a painter would do that, and they would be normal, they would be authors in the world of copyright law. They would create a drawing or a painting, and they could claim copyright protection on it. But today, at least in the United States Patent Office, they said for the same logic that AI purely cannot be an inventor because it's not human, that the current copyright law in the United States and the rest of the world says that copyright belongs to the author, and the author has to be a human. So AI, under US copyright law and most of the other copyright laws, you cannot claim copyright protection from the AI. Now, there's going to be another generation of litigation. Well, there's going to be another generation of codes and statutes, policies, procedures, guidance documents, which will result ultimately in litigation to see whether that's valid processes, policies, guidance documents, or legislations that are then going to talk about whether AI itself can be an author, or separately, what about the person who prompted it? Because if you think about it and say, is the intellect or the intellectual capability the person of ordinary skill in the art when you talk about it from a patent law purpose, or the skill of an author, pretend you're the painter and you're the painter's skills. It's my input into the search engine or the ChatGPT or the LLM model that it was my prompts and my requirements and my vision of what I wanted this figure or picture of Shashank with a full head of hair and making him look 10 years younger. So why should AI disqualify the copyright when in fact it's my input in the first place that just generated the image at the end of the day? So said another way, maybe I am really an author and I can claim copyright protection in the generated image because it's my input in the first place that generated the image, and the image was only generated by mechanical means or electrical means.
But as a follow-up question, if I'm using that image, can somebody really sue me that I am infringing because I just got it from AI? Can I be at the risk of infringement?
Well, so you can always be, I mean, in America we always say you can sue anybody for anybody. The question is, can you win, right? But the next thing that we think about is, okay, so I go into the AI model and I ask it to create the image. Now, let's just pretend I'm not using Shashank Upadhye with the bald head that I have right now, but I'm asking them to say, let me use the image of, and I ask them to create a new image of Michael Jordan, the basketball. I live in Chicago, so of course Michael Jordan is, the basketball player. Or I want to create a, whimsical image of Donald Trump. Now we call him the orange Cheeto, so maybe I have the AI, put an image of Donald Trump on a Cheeto, and then somebody else uses it. Can I sue them? Well, you can always sue people for copyright infringement. The question ultimately becomes is, number one, can you claim copyright infringement? And then what are your damages and what are your remedies? So I always tell people that, so for example, the example that I'll use is that Ariana Grande, Kim Kardashian, doesn't really matter, walks out on the street and the photographer, paparazzi, takes a picture of her and he posts it on his own social media, right? Of a picture of Ariana Grande in her leggings walking down the streets of New York. And she says, wow, that's a great picture of me. That's a really nice live picture of me. So she takes that image from the paparazzi photographer's social media and reposts it on her social media, okay? So this is a picture of Ariana Grande herself, taken by a photographer, posted on the photographer's website. Ariana Grande then says, that's a picture of me, so I'm going to take it and put it onto my website because it makes me look good, right? Or I like that real life picture of me walking down the streets of New York. Is that copyright infringement? And the answer is yes. Because even though she is the subject of the picture, she is not the owner of the copyright, the right to the copy. The original photographer was. And this happens all the time. Those photographers sue the celebrities all the time because the celebrities then take the pictures. So when it comes to AI, there's nothing intrinsically different than me going into an LLM model, creating an image, and then somebody else taking that image. It's still the question of it's copyrightable under common law, but then what damages you can get if you were to try to federally register it or internationally register it, you may be disqualified from that because it's not human.
Okay. So Shashank.
So that was a very long answer to a very short question.
Yes. So Shashank also, like the internet did, it made finding the prior art, like the documents, much easier in the past. Now AI has made it even easier, and people who don't know a lot about intellectual property, they can also go online, use a couple of tools and find documents online. Do you think all this will lead to a lot of litigation, a lot more litigation than it has been happening in the past? Just because it is so easy to find documents now with the use of AI.
Right, and so what Abhi's also raising is a very important point is like what happens if your entire business model is based on using somebody else's materials, digesting it for the purposes of training your model. And then your result is what you sell to your customers. That is actually going on right now. And that is, am I allowed to then use the AI to comb through, for example, all the different automotive manuals that are out there, or the pictures of all the other automotive manuals and the how-to manuals. And so I can create my own manual, and I'm training the AI on my manuals to create a manual for myself for my own cars, or I'm going to sell it to car companies based on other people, and that could be a copyright infringement. Even though you're using the internet to do so, AI is simply just, in certain aspects, is just faster internet, right? I mean, it's smarter internet, but it's still faster internet. The library or the world of prior art or prior documents that are around you. So, for example, suppose I'm in the legal field. If I wanted to create some type of news, like legal research tool, right? And I wanted to find out, case law, I cannot train my database of legal research using Thomson West's Westlaw or LexisNexis case law reporters. You can get sued for that, and why? Because you're not permitted to access their copyrighted materials for the purposes of training your new language model. So there's going to be a lot of new litigation. There's going to be litigation in the world of IP and AI, again, in the world of your patents. You talked about prior art, so then the question is, supposing you're trying to apply for a patent, there are some people, I don't know whether here in this room, but you might say, I don't want to pay Shashank as a lawyer, right? Because he's expensive. I can do it myself. I can file my own patents. I can draft my own patent application. So what do? You put the search into the query into a chat GPT model, and you say, this is what my invention is, or the characteristics of my invention. Please draft a patent application. Now I'll warn you about one thing. The minute you put it into AI, guess what you did? You devoted, donated, right? Gave it away, your invention, to the internet, to the world. Did you not? You don't have a confidentiality agreement with AI, do you? So the minute you put your query and say, my real key invention is how this algorithm works, or in the world of pharmaceuticals, what I do a lot of, is this secret formulation, or in medical devices, right? I use this alloy in the stents, so then the heartbeat can beat 12 million times instead of 6 million times before the stent fails. Well, the minute you did that, Anybody else can access that. You have just donated, and I want to emphasize the word donated, because you got nothing. You did not get paid. You donated it into the world. Now, the output might be a patent application. And if you quickly file a patent application, you can do it. But then again, the question is it worth it for you to use AI to draft a patent application in the first place? Now secondly, now that you've drafted a patent application and maybe you used AI to help you come up with some invention, and you file a patent application, in the United States you have a duty to disclose relevant prior art. Well, what are the documents that the AI relied on? Because the AI doesn't give you necessarily a citation, like every paragraph of the AI report that comes back. They didn't say, and the citation to it, and the citation, and citation. So now does the entire AI model or universe become the prior art for the patent application? And failure to disclose will disqualify your patent in the United States and jeopardize your patents on a worldwide basis, right? And then on top of that, willful infringement. Supposing you're just launching a product, you don't care about patenting your own stuff. So you ask the language model, am I infringing somebody else's patent? And the AI comes back to you with, no, you're not. Are you going to rely on that, or are you going to call somebody like us as lawyers to give you the so-called FTO report, or hire Abhi's company to do the FTO searches for you? And even if you say you get sued and you're going to lose, in the United States and other countries you can be sued for triple damages. So now you're going to be subject to triple damages. One way to mitigate triple damages is to say that, well, I had opinions of counsel or good faith belief that I didn't infringe. Well, are you going to go to court and say my good faith defense and infringement was, well, I typed it into the AI and they said I don't infringe? That's not a valid defense, is it?
So Shashank, a lot of these applications are eventually looked upon by the examiners at the patent offices, maybe India or US. How do you think these examiners are leveraging AI? Because if they're, say, searching the same database that probably a person is searching who is filing the application, there has to be some coherent thought between the two people. So how do you think, or do you have any insight into how these examiners, or they're not allowed to use at all, because in a way, again, that kind of crosses line with their duty?
Well, so for US Patent Office examiners, they're not allowed to use AI, because remember, when you file a patent application with the US Patent Office, it's confidential. The minute that the examiner types in the relevant or novel aspects of your invention into the AI, just in the same way you donated it, the patent office is donating it. If you donate it on your own, that's okay, foolish for you to do so. If the US Patent Office does so, you're like, wait, what did you just do? Right? You violated the rights of confidentiality. I didn't ask you to donate it into the thing. Now, where AI might be useful for patent offices, and in fact, we know judges in the United States sometimes use AI to understand some parts of the litigation or understand the technology. So, for example, sometimes the technology is complicated. Like again, I work in the world of pharmaceuticals, biologics, medical devices, food, beverage, and nutrition, dietary supplements. So I'm just going to use an example of a cosmetic lotion, right? And somehow it moisturizes your skin in a better way. And the litigation is all about the formulation and the unique aspects of the lotion and whether it can, moisturize. So you can use an AI, for example, to say, create a tutorial or a video that explains how a certain permeation enhancer will coat the skin and allow the moisturizer to permeate the skin. That is very useful, for an example, to understand then what are the new aspects and what are the old aspects. It would be very interesting for a judge to say, hey, I understand now what this law is about.
So, Shashank, I think we don't have much time left. So, from a future perspective, what are the top 2-3 things you think, like it happened in internet time, will come up, which will kind of regulate the whole environment from a legislative perspective, and also kind of take care of people using AI in their inventions? Do you think AI being an inventor will be allowed at some point in time?
Right. So I think the first thing is like organizations like TiE and then your national organizations need to petition for legislative change. Right. That's the first thing, because offices, the Indian Patent Office, U.S. Patent Office, Copyright Office, doesn't matter. They're regulated by statute. They may want to help you, but they can't because they're governed by statute. So you need to effectuate legislative change. Now, if you're in the United States, good luck trying to legislate changes in the next 4 years, right? Because, as we've seen for the last 43 days, we have a very dysfunctional government. There is no reason for our dysfunctional government, out of 1,000 problems that we have, to pick up whether AI should be patentable or not. So they're never going to pick that up in the United States for the next 4 years. Now, other things that you can do for legislative change, but for your purposes, one of the things that you need to have is robust policies on AI. How you use AI in your own businesses. Do you want your employees, especially if you're in some type of research and development or engineering, do you want them to use AI where in effect they're looking at your cutting edge technologies or your novel aspects and in fact putting it into the AI and actually donating it? And if you want to stop that, you need to have robust policies and procedures in place for your companies to, regulate how your own employees are jeopardizing your own IP, right? I mean, that's going to be critically important. Secondly, you're going to be thinking about the way you have AI and, like aside from your own policies, and that is, how are you going to do business with AI? Like, for example, are you going to rely on when you're launching products? Are you going to do freedom to operate searches? How are you going to avoid infringing third-party IP rights to the extent that it's, patents, trademarks, copyrights, right? Trade secrets, right? The Indian market is fluid when it comes to its employees, right? And you know that, and we know that. The employee you have today could tomorrow turn around and go to a competitor. How are you putting policies in place to protect your trade secrets? And are they, in fact, taking those trade secrets? So if you're relying on AI and you have some special algorithms or large language models, and you're using AI in that sense, how are you protecting that for potential theft of trade secrets when that employee takes it and goes to the next company? And remember, in India, a very big problem is that employees intentionally take the corporate materials so that they look good to the new employee, right? Or the new employer. And I know that because I had 10,000 people that work for me in Bangalore, right? And it just happens. And they would say all the time, I said, well, how do you know that's going to work? And they would say, oh, well, this is the way I did it at Dr. Reddy's, and they pulled out a USB stick full of all the corporate secrets. And I said, whoa, I don't want to touch that. I don't want to be receiving stolen trade secrets, right? Because in the US, that's a big problem. But in India, the fluidity of the job market is making it a significant problem. And then in terms of the future of AI, again, you're going to want to take a look at what you're able to copyright. And if you can't copyright it, what are the other types of IP protection that you're going to use? And I would suggest one thing is strong contract law, right? Making sure that your contracts are robust. Contracts that you have with your suppliers, contracts that you have with your vendors, contracts that you have with your customers, about regulating what they can and can't do with AI-generated innovations. Maybe it's not patentable, but you may be able to protect it through contract law.
Maybe we can open the house for questions to the audience.
My simple question.
Oh, anybody's through starts, my simple question becomes a
Okay,
PhD
so
question.
I have a peculiar situation. If you can help me, how would it look like? We have a situation where, we go to court for patent protection, we have IP protection, copyrights and all that. Someone is in violation of that. One is litigation and a person loses. Another thing is, he puts that stolen thing on the AI and it's donated to the entire world. And when the litigation happened, he says, I picked up from AI, I didn't steal it, and it's an open forum, I picked it up from there, so I can never be called in violation of a patent. So it's a via media of legalizing a steal.
Yeah.
Okay, now it's a very nice way of saying, if the court sits and he says that, see, it's on AI, I never did anything wrong. I picked it up from there. In reality, he was the one to put it on there, made it legal, quasi through AI, and then put as a defense before the court that this was in AI, and I simply picked it up. I was
It's fair use, basically.
Yeah, exactly.
Right?
So it could be a via media of making a violation legal. So it's a very peculiar thing which I felt I could ask you.
Yeah, no, and that's a great point. You know, and again, how do we solve that problem in the first place? You can't. In the end, because once it's in the AI, there's no ability to withdraw it from the AI.
Second aspect. Now, what's the sanctity of the IP litigation and protection as a whole when things are becoming an open forum? I mean, the entire legal practice of IP and filing a patent and having a contest and having a judgment. It all nullifies when you have something being put open.
Exactly.
And the litigation becomes a damn quick because everything is out in open. So how do we
and your only resource or problem, like first it becomes an evidentiary problem, right? You'd have to be able to prove that this person stole something from you and then uploaded it into the AI, right? So again, that's a forensic computer problem. And we've done this all the time. Every company, like when I was general counsel at my companies, every company worked at, we had keystroke tracking. We could see exactly, you know, what folders you went to and download it. And again, it's always amazing that people, when they quit, they always give their proverbial 2 weeks notice, right? But 2 weeks, well, maybe in India it's like 90 days or a month notice. But for months before that, they've been secretly downloading all the files to the USB sticks, right? Now, all you people in IT know that it takes almost 2 milliseconds for me to figure out what files you went to and where you downloaded it. And I said you put it on a Kensington, 32 gigabyte USB stick. That is the only remedy you have, is to prove that this guy did it. Now, once he did it, and you can prove that he did it, you might be able to claim whatever damages you can. And if that means bankrupting him, you might have to bankrupt him. If it's a company, you go after the other company and bankrupt the company. But the one remedy that you're really looking for is that I want to take what was confidential, made public, and make it confidential again.
Now we have a lone wolf system. We have a single person who did that. He's not in litigation, but the one who benefited is in liaison with the lone wolf and all that. So basically the files, the one who picked up the files would never come into the fore. But the one who benefited is someone else, because so that's a very peculiar thing of evidentiary value. How do you forensically also? Because forensically the single person is never claiming patent, nor did he do anything about that. But somebody else is benefiting because he passed the knowledge to him.
But your forensic science or your forensic evidence or forensic investigation will determine at least who is the initial culprit. Now, whether that initial culprit is in conspiracy with the other company, or he was truly a lone wolf and just said, like Eric Snowden, right? He violated all the Pentagon secrets, but he didn't get any money for it. He wasn't working for anybody. He just thought, this is what I'm going to do and publish it. Now, if the US government can't take the Pentagon Papers back from what Eric Snowden did, then you're not either. But your problem, of course, is then say, if you have a single person and you can track that person, then through investigation you might have to say, oh, that person worked in conspiracy with somebody else, and then you can bring them in as a defendant to the lawsuit under a conspiracy model. And remember, theft, like when it comes to trade secrets or theft of trade secrets is I steal trade secrets, right? That's what most people think of theft of trade secrets. I stole some of the corporate trade secrets, the secret Coca-Cola formula. But that's not what theft of trade secrets is only. Theft of trade secrets is also knowingly receiving information as a recipient, knowing that it was stolen. So if I go steal the Coca-Cola secret formula, and then I try to sell it to somebody, and that person says, what is it? I said, it's the secret Coca-Cola formula. Well, isn't it secret? Yeah. Well, how'd you get it? You don't need to know that. That person can get jailed also criminally. Now, unfortunately, in your case, the way you talk about it, it could be a civil violation from the infringement aspect. But once you prove that somebody has stolen trade secrets, at least in the United States and Canada, is that you can have them criminally prosecuted. So maybe, at the end of the day, your satisfaction is the guy goes to jail.
We don't have such enforcement over here.
I know.
And second aspect is, in our contracts, the best is confidentiality, NDAs and all that. But anti-competition, there's no law because life to, profession and life to liberty. I mean, you can't prosecute a person for joining the competition. And even if you have it in the contract that you can't join the competition, it's struck down.
Yeah.
So the confidentiality is the only thing which one can play around over the NDA and the clause. So that's what I thought I'd let you know. In India, that's the way it works.
Yeah, and again, in the United States, it's the same thing, right? So many of these covenants not to compete and these non-solicitation agreements, or you can't join a separate company, are being struck down in the United States, and so you only rely on confidentiality. But with employee movement from company 1 to company 2, company 2 is the one that really cares about whether they're a defendant in the lawsuit. Right? So again, if you're trying to enforce a theft of trade secrets against this rogue employee that went, don't just go after the rogue employee, sue the second company too, saying you know that he took this. And let them defend on the ground, no, I didn't know anything. Right? And what will eventually happen is they'll fire the person. Right? And you'll structure some settlement with the thing. But your fundamental point is the same, and that is because the minute you hit enter in AI, it's up there in the world for the world to see forever. There is no withdrawal mechanism because that's not the way AI is built.
And it could be out of vindictiveness that the employee is putting up in the world.
Sure.
Maybe a 10th person picks it up and he says, I have no clue about who's put it up.
And that's fair use. That's fair use.
Foreseeable anyway. I mean, it can't be enforced in the books at all.
I mean, again, if a rogue employee, and again, if I pick up, let's see, what's a regulated industry here in India? Like a very well-regulated industry that has to have lots of policies and procedures. Banking. Right? So now, if you have an electronic interchange company and you're trying to do the next UPI type of software payment plan, and you go to the internet or the AI and say, draft a whole bunch of policies on, electronic exchange of funds. And that AI itself is relying on State Bank of India, Republic Bank, ICICI Bank, because some rogue employees went up there and put all of the policies and procedures up there. The AI is ambivalent, right? It doesn't have an emotion. It doesn't say, oh, I shouldn't be doing that. It's going to say, thank God it's there. It makes my job easier, right? And it copies it and creates the policies and procedures for you. And that's the nature of that's the nature of AI in that. It's just emotionless. Does anybody have any other questions? Yeah, go ahead, sir. Okay, there's no other session right after this, right? So I think we can go a little bit over. Okay.
So just to so in this world of AI and IP, the biggest question asked is that who is to be protected, the developer or the deployer? It's a typical question that always comes in.
Well, I think when you talk about the ownership, when you talk about AI and IP, you're really asking some very fundamental questions, and that first and foremost is the result of the AI in and of itself protectable under any of the IP and the regimes. Typical IP regimes are your patents, trademarks, copyrights, and trade secrets. So is the end result even protectable? So let's say it is protectable. Then the question is, who owns that protection? Who owns that IP? Is it going to be the applicant or the developer? Now typically as a company, you have contracts or employment agreements with your employees that say anything that you do, on company time belongs to the company. So that's how you try to claim ownership of, obviously, if you're Pfizer and you hire chemists and they develop the next Lipitor, they own it, right? Because they're sponsoring all of that work, and this is what your job is to do. Now, what happens if the flip side is that you're a banking company or an internet search engine optimization company in IT, and then your coder goes home and then develops a new algorithm or app on where to find the best pizza, or which pizza is having a sale. Well, then there's a second question of, well, your day job is to do search engine optimization and blah, 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 or whatever it is, but you develop this new app, on, where's the nearest pizza store and what's the price of the pizza? Is that related to the day job, or can the developer or that coder claim separate IP, separate protection, saying, no, you don't have rights to that?
That's the question most of the IT companies have when they're developing.
Well, and again, it depends on the fluidity, because to this gentleman's point is that you cannot stop somebody from exercising their general skill and knowledge, right? Their general skill and knowledge is their expertise. That's inherent in them. It's really why we hire senior level people, because they have experience, right? And they bring general skill and knowledge. So with that in mind, but that becomes a question of the robustness of your employment contracts, clearly defining what is out there. So I'm going to give you, for example, it's my own law firm, and I have my partners in my law firm, but we're a boutique law firm, an IP boutique law firm. So my day job is to be a lawyer, and my day job is really to be a patent lawyer. Now, because I know how to write, and I have ideas, and I deal with people creative people all the time, if I go home and I write a novel, and it's a crime novel, and there's a crime and police investigation of the murders, and then ultimately the prosecution and the defense of the murders, and I publish it, just like John Grisham, would my law firm own it? And they say, well, you're a lawyer, and you kind of wrote a legal thriller. So we own your legal mind, so anything you did as a lawyer, and your legal writing part-time belongs to the law firm. So the royalty checks go to the law firm.
And that's very much there, reviewing contracts for the firms. When as a lawyer, you typically, we also come across that most of the contracts have whatever intellectual cap being developed under a project is the ownership of the owner of the project. So that is typically there. And as you rightly said, there is a lot of absence of the artificial intelligence laws across the globe, not only in India.
And one of the things that you may need to do, like again, if you're hired by, I'm just going to say Ford Motor Company here in Chandigarh, and you run an IT company where you're doing some implementation of some project to facilitate, the manufacture of the car for Ford, and you're being hired as the outsource, Ford, you will probably own the code, right? Ultimately, because what you're doing is work made for hire. But then the second question is, what happens? You say, well, now that I've done all this work for Ford, why not I contact Chrysler, right, and Maruti Suzuki and Mahindra, and say, like, maybe I can peddle the same type of project. Well, are you going to be in violation of potential copyright laws now? And then from an AI perspective, what if you were to put it up in the AI and say, well, now I can go to Suzuki and Suzuki and Maruti and whatever else, and say, well, it's in the AI, I'm just downloading it. You would have a problem with that. But the robustness of the contracts are going to be important. And I would always highly suggest with any of your employees that you also have to put down in the contracts whether you want them to use AI or you categorically exclude them from using AI. And then what's the punishment if they use AI or they do anything in violation of their employment contract?
I have seen a very refined ways to even write AI in no contracts. Typically to write that this is this, any automation, any development, any further development, any related development, all those commas, full stops, to say that whatever comes out of it is owned by us.
Yeah.
That's the protection now people are building, but still, it has to be tested in law.
Right, and again, if Ford, in my example, puts that into the contract with your company, you have a choice. Don't sign the contract and don't take the project if you don't want all of these restrictions on what you can and cannot do. Because again, then you'll have an argument over the degree of the change that you're making or the next innovation, and whether that next innovation really belongs to you or belongs originally to Ford. And remember, this could be years later.
Yes.
Right?
It's a long tail.
Yeah, it could be a long time after the Ford contract and project is over, and then you do the next innovation or the next stage of the innovation, and Ford comes back 10 years later and says, oh yeah, that still belongs to me.
Definitely. Thank you.
Yep. Are there any other questions? No? Perfect. Okay, thank you very much, everyone.
Right, thank you. Thank you everyone for joining in.
Thank you, Abhay.
Thank you so much, Mr. Shashank and Mr. Abhay, for being here. Can I request Mr. Vikram Kapoor from your company is Fitness Architects, right? Please come on the stage and felicitate our guests today.
Thank you so much, everyone, for your presence, and thank you so much for such an amazing session.